Imagine walking down the aisle in London. You say your vows, you sign the register with your new spouse, your friends are throwing confetti.
Yeah, it's the perfect day.
Right. You walk out as a legally married couple, ready to start a new life, and everything is perfectly legal under English law.
Or so you think.
Exactly. But then, imagine finding out a few years later that because of a retroactive law passed in Austria, a country you literally haven't visited in years, your new marriage in London is completely void.
Oh, wow. Yeah.
You are not a legally married spouse. You are basically accidentally and entirely without malice a bigamist.
I mean, it sounds like a terrifying administrative glitch, right?
Yeah.
But it is an actual, very real scenario that played out in the highest courts.
It really did.
It perfectly illustrates the terrifying invisible borders of what we call private international law.
And that is exactly the world we are exploring today on the Deep Dives. We are looking at a legal landscape that governs, our most intimate relationships.
Right. Who we can marry, how we can divorce.
Who gets custody of the children, especially when those relationships cross international borders. Because when couples move between countries, the foundational rules of their lives become incredibly murky.
They really do. It is no longer just about reading a single set of local statutes. It's about understanding which country's statutes even have the right to govern you in the first place.
Right. And for you listening today, we're putting you in the shoes of a law professor.
Ooh, I like that.
Yeah. Your syllabus today is actually based on the Osmania University LLB Honors Semester the Fifth course, specifically Unit 3 of Private International Law.
That is a dense, fascinating unit.
It is. So to start us off, I feel like it's helpful to draw a distinction right away because the term international law, it usually brings to mind the United Nations. Right?
Yeah, or like the Geneva Conventions or treaties between massive state actors.
Exactly. But that is public international law.
Right. What we're discussing today is private international law. It's often abbreviated as PIL, or sometimes it's called the conflict of laws.
Conflict of laws. I like that name.
It's very descriptive. PIL deals with private citizens. It deals with individuals or corporations who find themselves in a dispute that involves a foreign element.
Okay, a foreign element, meaning it's not just two people who were born, raised, married, and separated in the exact same town.
Precisely. It is the body of law that comes into play when the issue before a domestic court affects facts or events that are so closely connected with a foreign system of law that the court is forced to look outward.
So the judge is sitting there thinking, wait, do I apply our law or do I apply the law of France?
Or India or Nevada. Exactly. The court has to ask itself that exact question. And the stakes are deeply personal. Getting this choice wrong leads to one of the most difficult problems in family law.
Which the syllabus calls the limping marriage.
Yes, the limping marriage.
That is just a visceral, brutal term.
It really is.
Reading through the materials, a limping marriage is basically a situation where a couple is legally considered married in one country, but they're viewed as completely divorced or even unmarried in another.
Yeah, you cross an invisible line on a map, say stepping off a plane from Mumbai to London, and your entire civil status fundamentally changes.
It's wild. You might be a wife in one jurisdiction with all the legal protections and financial rights that entails, and then you're a legal stranger to your partner in another.
Exactly. And our goal today is to understand how courts try to cure this legal limp. We are focusing specifically on the interplay between Indian and English legal traditions.
Right, to see how they navigate this maze of competing jurisdictions to find, like, a unified answer to civil status.
So to even begin navigating that maze, before a judge can look at a marriage certificate, they have to figure out the rules of engagement.
Meaning they have to decide which country's law applies first.
Yes. And reading through the case law, the very first step a court takes when a case with a foreign element lands on the docket is a process called characterization.
Or classification, right?
Right. It is the absolute foundation of PIL. The court cannot just randomly pick a jurisdiction. It has to classify the fundamental nature of the legal issue at hand.
So the judge looks at the facts and asks, is this a contract dispute or is it a matrimonial issue?
Exactly. Or is it a matter of property succession? And the reason this is so critical is that the choice of law rule, the arrow pointing to the correct country, depends entirely on how the issue is categorized.
Let's ground this in a real scenario from the historical sources.
Oh.
The case of Dinicles Vicurlier.
Oh, that is a perfect example of how wildly different the outcomes can be depending on this initial classification.
Right. So we have a French man and a French woman who marry in Paris. And they don't sign any express prenuptial agreement regarding their family property.
But under French law at the time, if you marry without an agreement, your property rights are automatically regulated by a default rule.
The community of property rule, right, meaning basically what is yours is ours.
Precisely. And that works perfectly well as long as they stay in France. But they don't.
Of course they don't.
The couple later moves to England, they build a whole life there, and the husband eventually dies domiciled in England. And he leaves behind a will.
And here's the twist. His English will basically ignores the wife's rights under that original French community of property rule.
Yeah, he tries to distribute the assets as if he were an English gentleman governed entirely by English property laws.
So the widow, understandably, sues in the English courts to get her rightful share. And this is where the English judge faces a massive characterization problem.
A huge one. Because if the judge looks at this and says, well, the man died and left a will, so this is a question of testamentary succession.
Meaning the laws of inheriting an estate.
Right. If it's succession, then under English PIO rules, succession is governed by the law of the place where the man was permanently living when he died.
Which was England. So if it's characterized as a succession issue, English law applies, his English will is entirely valid, and the widow loses all her French protections.
Exactly. But there is another way to look at it. The widow's legal team argued that this wasn't about a will at all.
They said it was about a contract.
Yes. They argued that when they married in France, the French law of community property acted as an implied contract made at the very moment of their union.
Oh, that's clever. And if the court categorizes it as a contract issue,
then the choice of law rules point to the law of the place where the contract was made.
which would be French law.
Exactly. And the House of Lords ultimately agreed with the widow. They classified the issue as an implied contract arising at the time of the marriage in Paris.
Wow. So because of that classification, the rights she acquired at the moment of marriage were completely unaffected by their move across the English Channel.
Right. French law applied to the distribution of the assets, and she won her share. It just goes to show how the mere act of labeling the dispute dictates the entire outcome.
And it is worth noting that this initial classification is almost always done based on the lex fori, right?
Yes, lex fori. That is a Latin term meaning the law of the forum.
But court hearing the case.
Exactly. The court hearing the case will use its own domestic legal definitions to draw those initial boundaries. An English judge uses English concepts of what constitutes a contract.
Okay, so once the court has characterized the issue, let's say they decide, yes, we are definitely dealing with the question of matrimonial status, they still have to figure out who these people are legally tethered to.
Right. How does the court decide which country's laws govern their status?
And this brings us to the ultimate connecting factor for civil status in both the English and Indian legal systems.
The concept of domicile.
Domicile. It's one of those words that people just throw around interchangeably with residence or citizenship in everyday conversation.
They do, but in private international law, they're vastly different concepts. Confusing them is where massive legal errors happen.
So let's break it down. Nationality versus residence versus domicile.
Okay, so nationality or citizenship is your political connection to a sovereign state. It is the passport you carry.
It dictates your right to vote, paying taxes, things like that.
Right. Now, residence is simply the physical place where you happen to be living at any given moment. You can be a resident of a hotel in Tokyo for 6 months while holding an Indian passport.
But domicile is something much deeper.
It is. The legal definition often frames it as your permanent home. It is the place where you reside with the absolute intention of remaining there permanently, or at least indefinitely.
It is the place you always intend to return to, even if you're currently wandering the globe.
Exactly. And the fundamental rule in English and Indian PIL is that a person's civil status, their capacity to marry, their right to divorce, is governed universally by the law of their domicile.
Regardless of where they happen to be standing at the time.
Precisely.
You know, it's really like a smartphone.
A smartphone? How so?
Well, think about it. Your nationality is the hardware like the Apple or Samsung logo stamped on the back of the device. That tells you where it was manufactured.
Okay, I follow you.
But your domicile is the operating system actually running the apps in the background.
Oh, that's a great way to look at it.
Right. Like, if you are an Indian citizen holding an Indian passport, but you move to the UK with the firm, verifiable intention of making London your permanent home for the rest of your life.
You've essentially downloaded the UK operating system.
Exactly. Your hardware still says India, But because you changed your legal domicile, your personal apps, your marriage app, your divorce app are now running on UK code.
That is a highly accurate way to visualize it. The Indian courts will actually look to UK law to determine your civil status because your permanent legal anchor has shifted.
Now, this reliance on domicile makes sense on paper. You want people to be governed by the laws of the community they've actually chosen to integrate into.
Right, it's logical.
But reading through the jurisprudence, this system creates an incredibly bizarre loophole when different countries use different connecting factors.
Ah, yes. What happens if my new operating system has a fundamental disagreement with my hardware about who is actually in charge?
Exactly. And you're describing the doctrine of renvoi, which honestly is probably the most intellectually dizzying concept in all of PIL.
It is a nightmare for law students. Renvoi. It translates from French roughly as to send back or return.
How does a legal system send a law back? Let's use the Ross case to break down the mechanics of this, because trying to read the bare summary requires a flowchart.
Ross is the classic illustration. We have a British national. That is her hardware, her passport. But she has moved to Italy.
And she lived there for a long time.
Yes, she legally established her domicile, her permanent home in Italy. Then she passes away, leaving behind movable property.
And the legal dispute over her succession lands in an English court.
Right. So the English judge looks at the case, they run their conflict of laws rules, and the English rule for succession of movable property says, we look to the law of the deceased's domicile.
And the judge sees she was domiciled in Italy.
Exactly. Therefore, the English judge points the arrow to Italian law. They say, Italy, you tell us how to distribute this property.
But here is the critical juncture. When the English judge points to Italian law, do they mean the internal domestic laws of Italy?
Or do they mean Italy's conflict of laws rules? That's the million-dollar question.
And this matters because Italy, like a lot of civil law countries in Europe, doesn't actually use domicile as its connecting factor.
Right. Following the French Revolution, much of Europe shifted to using nationality as the anchor for personal laws. They believe a citizen's connection to their state is unbreakable.
So the English judge points to Italy because of her domicile, but the Italian conflict of laws rules look at her and say, wait, she's not an Italian citizen.
Her passport is British. For matters of succession, we look at the law of her nationality.
So Italy refuses the jurisdiction. The English court forwards the legal mail to Italy, and the Italian legal system stamps it, return to sender.
And forwards it right back to England saying, she's your citizen, you deal with her.
That return to sender moment is the renvoi.
Exactly. The question for the English judge is whether to accept the returned mail. If they accept the renvoi, they basically say, fine, Italy doesn't want to apply its domestic law, so we will apply internal English law.
And in Ross, the English court did exactly that.
They did. They accepted the renvoi and applied English internal law.
It is just a massive jurisdictional loop. England says, look at where she lived. Italy says, look at her passport.
It's dizzying. And the loop can involve even more than two countries.
Right. The Forgo case introduces a third party to the chaos.
Forgo is a fascinating piece of legal history from the French courts. Forgo was a Bavarian national. Bavaria was a sovereign kingdom at the time.
He was an illegitimate child brought to France at a young age.
Yes. He lived almost his entire life in France, acquired wealth there, and died leaving movable property in France.
But he never took the formal bureaucratic steps required under French law at the time to officially establish a legal domicile in France.
Correct. He lived there in reality, but not in strict legal fiction. He died without a will and had no direct descendants, just some very distant collateral relatives in Bavaria.
So the French court has to decide who gets the estate, the distant Bavarian relatives or the French state, which claims the property of people who die without heirs.
So the French judges consult their conflict of laws rules. Because Forgo lacked a formal French domicile, the French rules pointed to the law of his nationality.
They pointed the arrow to Bavarian law.
But when the French courts looked at the Bavarian conflict of laws rules, they found something entirely different.
What did Bavaria say?
Bavarian law stated that succession of movable property is governed by the law of the place where the deceased actually lived or where the property is situated.
The lexitus and the habitual residence.
Exactly. And Forgo lived his whole life in France, and the property was in France. So Bavaria points the arrow right back to France.
A double bounce. And what did France do?
The French courts accepted this remission, this renvoi. They accepted the jurisdiction that Bavaria sent back to them.
And because they were now applying internal French domestic law, what happened to the Bavarian relatives?
They were cut out entirely. Under French internal law, Illegitimate children's distant relatives had no inheritance rights. The entire estate was absorbed by the French state.
Wow. It is incredible how these abstract theories of jurisdiction translate directly into who inherits a fortune.
The choice of law isn't just an academic exercise. It is the entire ballgame.
It really is. Okay, let's move from the end of life to the beginning of a new one. We've established how courts categorize issues and use domicile.
Right.
How does all of this machinery work when two people cross a border and try to form a marriage?
Forming a marriage in PIL requires navigating two very distinct sets of rules. It is a dual hurdle system.
Dual hurdles, formal validity and essential validity.
Yes, if you want your cross-border marriage recognized globally, you must establish both.
Let's break those down. Formal validity seems to concern the how of the marriage.
Precisely. The ceremony, the paperwork, the physical act. Do you need 2 witnesses or 4? Does it have to be a civil magistrate, or is a religious cleric enough?
Are marriage bans required to be published? Things like that.
Exactly. And the golden rule here provides a rare moment of clarity in PIL. It's governed by the Latin maxim lex loci celebrationis.
The law of the place where the marriage is celebrated.
The place governs the act.
Yes, meaning if I decide to have a destination wedding in Japan, I don't follow Indian procedural rules. I have to follow Japanese rules for the ceremony.
Exactly. If you get married on a beach in Brazil, you follow Brazilian procedural laws. The preeminent legal scholar, Dr. Cheshire, summarized it perfectly.
What did he say?
He stated that if a marriage is formally good by the law of the country where it is effected, it is good all the world over.
Even if that specific type of ceremony wouldn't be recognized in your home country.
Right. And the rationale for this is rooted in practicality. If every country insisted its citizens must follow home rules everywhere, the global system of civil registries would collapse.
Right. A Mexican registrar can't be expected to know how to perform a legally binding Hindu traditional ceremony just because the couple is from Delhi.
Exactly. It is entirely about comedy and practical administration. You play by the rules. And courts are incredibly strict about enforcing this.
If you fail the local formalities, your marriage is formally invalid everywhere, like the Berthiaume v. Dastus case.
That is a harsh reminder of this strictness. We have 2 individuals domiciled in Quebec, Canada. They are traveling in France, and they decide to get married there.
And they are devout Catholics, so they go to a local Catholic church and have a traditional religious ceremony.
The priest pronounces them husband and wife. Now, in their home province of Quebec, a religious ceremony carried significant weight.
But they were in France.
Exactly. And under French law at the time, a religious ceremony alone carried absolutely no civil legal weight.
Yeah.
France strictly required a civil ceremony before a state official.
So they basically just missed the crucial bureaucratic step.
They failed to satisfy the lex loci celebrationis. Because they didn't meet the mandatory formal requirements of the place where they stood, the court held the marriage was formally invalid.
Legally, they were never married.
Despite their intentions, yes.
That is brutal. But there is a fascinating flip side to this rule. Because if the place of celebration dictates the formalities, you can theoretically use geography to bypass restrictive rules at home.
Matrimonial tourism, yes. The case of Simenon v. Mellac is the classic example.
Tell us about that one.
2 French citizens living in France want to get married. But under the French Civil Code, individuals under a certain age required the formal legal consent of their parents.
And I'm guessing the parents refused.
They did. So they are blocked in France. What is their workaround? They simply cross the English Channel.
They travel to England?
Yes, where English law regarding formalities didn't mandate parental consent for individuals of their age. They get married in London, completely bypassing the French restriction.
Wow. And later, the marriage breaks down and the wife files a petition for nullity in the English courts.
Right. She argues that because they were French citizens and French law demanded parental consent, which they explicitly evaded, the marriage should be void.
But the English court dismissed her petition, didn't they?
They did. The judge reasoned that parental consent was merely a matter of formality, not fundamental capacity. And because formalities are governed exclusively by the place of celebration, England, the marriage was formally valid.
The English courts basically said, we are not acting as a police force enforcing French parental control laws.
You followed our local wedding rules. You are legally married.
But the dominance of the lex loci rule can also lead to outcomes that border on the surreal. Let's go back to the scenario I mentioned at the very beginning of the show.
The accidental bigamist. Starkowski v. Attorney General.
Yes, this case is mind-bending. Set the scene for us.
It's deeply tied to the chaos of post-World War II Europe, May 1947. We have two Roman Catholics who are domiciled in Poland, but they are displaced persons living in Austria.
And they decide to get married in a Catholic church in Austria.
But just like the Berthiaume case in France, Austrian law at that specific time required a civil ceremony for a marriage to be legally binding.
So the church ceremony alone wasn't enough.
Exactly. So in May 1947, under the strict application of Lex Loci Celebrationis, their marriage was formally invalid. Legally, they were just two single people cohabiting.
However, the Austrian government quickly realizes they have a massive crisis on their hands. Thousands of displaced people having church weddings, completely unaware of the civil requirement.
Creating a crisis of illegitimate children. So the Austrian government steps in to fix it. A few weeks later, Austria passes a sweeping new law.
The retroactive law.
Yes. The law states that these previously invalid church marriages can become legally valid retrospectively if they're officially registered with the state authorities.
Meaning the state looks backward in time and says, we officially recognize you were legally married from the day you stood in the church.
Yes, but here's where the timeline becomes critical. The official registration of their marriage under this new law didn't actually happen until 1949.
And by 1949, the couple had already left Austria.
They had moved to England, acquired an English domicile, and critically, their relationship had completely broken down. They separated.
So from the wife's perspective, she was married in a church in 47, found out later it wasn't legally binding, separated, and moved on.
Precisely. Believing she was a single woman because the first marriage was formally defective, she meets someone else in England. And in 1950, she gets married again in an English ceremony.
But wait. In 1949, the Austrian registry finally processed the paperwork for her first marriage.
The trap is sprung. The case reaches the House of Lords. The core legal question is her second marriage in England valid?
And to answer that, the English court had to decide if they respected the retroactive Austrian law.
And because English courts bow completely to the Lex Loci Celebrationis, they accepted the Austrian retrospective law.
They did?
They ruled that because Austria was the place of celebration for the first marriage, Austrian law dictated its formal validity. If Austria says a law can reach backward in time, England respects that.
So the House of Lords declared that her first marriage became fully valid in 1949, which means when she stood at the altar in England in 1950,
she was already a married woman. Her second marriage was bigamous and completely void.
That's wild. The dominance of the Lex Loci is so strong it literally altered her marital status across borders and backward through time.
It highlights the uncompromising nature of the rule. However, the law does recognize that absolute rigidity can lead to impossible situations.
Right, like what if you were shipwrecked on a deserted island? Or in a territory with no recognizable civil government?
Exactly. You cannot satisfy the Lex Loci if the locus has no lex.
So what's the exception? How do you get married stranded in the wilderness?
English law developed the doctrine of the common law marriage as an exception of necessity. If there was an insuperable difficulty in complying with local law, the marriage could be valid if it complied with the basic tenets of English common law.
And what does common law require, stripped of all the bureaucracy?
At its core, it requires only that the parties freely and voluntarily take each other as husband and wife. It's the meeting of the minds.
So that covers formal validity, the paperwork, the ceremony. But we mentioned there was a second, much higher hurdle.
Essential validity, the if.
Capacity to marry. Who actually has the legal right to marry whom?
This is not about paperwork. This deals with profound issues of public policy. It covers consanguinity, can you marry your cousin? Bigamy, legal age of consent.
And unlike formalities, essential validity is absolutely not governed by the place of celebration.
It cannot be. If capacity were governed by the place of celebration, a 40-year-old man from a strict jurisdiction could simply fly to a country with no minimum age laws, marry a child, and demand his home country recognize the union.
Which is horrifying. So PIL insists that your capacity to marry is tethered to your home.
It follows you wherever you go. The massive debate in the courts has been, which home law follows you?
Let's start with the traditional approach, the dual domicile theory.
It's straightforward but rigorous. For a marriage to be essentially valid, both parties must have the legal capacity to marry each other under the laws of their respective pre-marriage domiciles.
Both operating systems have to say yes.
Exactly. Let's look at the 1861 case of Brooke v. Brooke. It involves a man, William Brooke, who wanted to marry Emily Armitage.
But Emily was the sister of William's deceased first wife.
Right. And in 1861, under English law, marrying your deceased wife's sister was strictly prohibited. It was considered void for reasons of consanguinity and affinity.
And both William and Emily were permanently domiciled in England.
So they know they can't get married in London. They decide to pull a Simon and Vimalak. They travel to Denmark, where this type of marriage was perfectly legal.
They have the ceremony, comply with Danish lex loci, and return to England. But later, a dispute arises over property, and their marriage is challenged.
The Lord Chancellor struck the marriage down completely. He drew a razor-sharp line between form and essentials.
Because they were both domiciled in England and English law said they lacked capacity, the marriage was void from the start.
It didn't matter that Denmark gave them a certificate. Denmark couldn't grant them a capacity that their home country had explicitly stripped away.
That is the dual domicile theory operating at its peak. But then a rival theory emerged, right? Dr. Cheshire's theory.
Yes, the intended matrimonial home theory. Cheshire argued the dual domicile rule was too rigid. He proposed that capacity should be governed by the law of the husband's domicile at the time of the marriage.
Because historically, that is where the parties intended to establish their permanent home. But looking at the history here, that relies entirely on the common law rule of coverture, where a woman's independent legal identity was suspended upon marriage.
She automatically acquired the domicile of her husband. It was a deeply patriarchal legal fiction.
Lord Denning had some strong words about that, didn't he?
He vehemently attacked it. He called the rule of a wife, automatically taking her husband's domicile, the last barbarous relic of a wife's servitude.
Barbarous relic. That is incredible language from the bench.
Because of that recognition, the courts gradually evolved Cheshire's theory into the matrimonial domicile theory. Where do the parties jointly intend to establish their shared home?
Like in de Renneville v. de Renneville.
Exactly. An English woman married a French man in Paris. Their clear, mutual intention was to build their life in France. They lived there for years before separating.
She moved back to England and filed for nullity.
And Lord Green ruled that essential validity was governed by French law. Not just because the husband was French, but because France was the intended matrimonial domicile.
It makes an intuitive sort of sense. You anchor your marriage to your shared future, not your divided pasts.
It's a much more pragmatic approach.
Okay, so we've mapped the gateway, we tied the knot, but the syllabus requires us to look at the entire life cycle. What happens when the marriage falls apart?
The jurisdiction of the court, whether a judge even has the authority to hear your case, is the fiercest battlefield in PIL.
Before we get into that, let's clarify the matrimonial causes: divorce, nullity, judicial separation, and restitution of conjugal rights. What's the difference?
A divorce dissolves a legally valid existing marriage. It terminates it prospectively. You are free to remarry.
A cancellation moving forward.
Right. A decree of nullity is retrospective. It declares that because of a fundamental defect like bigamy or lack of consent, the marriage never legally existed in the first place.
It erases it from history. And judicial separation.
A formal court order acknowledging the marriage is broken and parties can live apart, but the legal bond remains intact. You cannot remarry.
And restitution of conjugal rights.
Mostly antiquated now, but it was a court order directing a spouse who had withdrawn from the marriage to return and resume cohabitation.
Wow. Okay, focusing on divorce. Where do you go to file when the marriage is international?
Historically, the English rule was devastatingly strict. The Le Mesurier doctrine. Domicile affords the only true test of jurisdiction.
Meaning you can only file for divorce in the courts of the country where you are permanently domiciled?
Yes. And because of that barbarous relic rule where a wife acquired her husband's domicile, this created immense human suffering.
Think about an English woman who marries an American, they move to New York, he becomes abusive, and she flees back to England.
Under Le Mesurier, the English judge would tell her, your husband is domiciled in New York. Therefore, legally, your domicile is in New York. We have no jurisdiction.
The law demands she cross the ocean to fight her abuser in a foreign court. Just awful.
It was so glaring that the courts had to dismantle the Le Mesurier straitjacket. They started with reciprocity in Travers v. Hawley.
We will respect your jurisdictional flex if you respect ours.
Right. But the real earthquake was Indica v. Indica.
What happened in Indica?
A Czech national marries in Czechoslovakia, leaves his wife, moves to England, and acquires an English domicile. The first wife stays in Czechoslovakia and gets a Czech divorce decree.
He then marries a second English woman, and when that breaks down, he tries a cynical maneuver.
He argues that when his first wife divorced him, his domicile was in England. So under the old rule, only England had jurisdiction to dissolve the first marriage.
Meaning the Czech divorce was invalid, he was still married to wife one, so his second marriage was void for bigamy.
Exactly. But a House of Lords refused to let him weaponize the old rule. They recognized the Czech divorce because the wife had a real and substantial connection to that jurisdiction.
That's a massive leap forward, but real and substantial connection is pretty vague, right?
It is, which led to unpredictability. So Parliament stepped in with the Recognition of Divorces and Legal Separations Act of 1971.
And what did that act do?
It explicitly stated that English courts will recognize a foreign divorce if either spouse was habitually resident in that country or if either spouse was a national of that country.
Ending the tyranny of strict domicile.
Exactly.
Now, how does India handle a foreign court claiming it has dissolved an Indian marriage?
India presents a unique challenge because it operates on a system of personal laws based on religion. Hindus, Muslims, Christians each have their own frameworks.
When an Indian citizen goes abroad, gets a quickie secular divorce, and returns, the Indian legal system has to act as a strict bouncer at the door of recognition.
They cannot accept foreign decrees blindly. The landmark case here is Y. Narasimha Rao v. Y. Venkatalakshmi.
This case is basically a blueprint for forum shopping. A couple marries in India under Hindu law. The husband goes to the U.S. for work.
He wants out of the marriage, but instead of filing in India, he travels to Nevada.
Famous for quick divorces, he lives there for exactly 90 days.
The bare minimum to claim residency. He declares Nevada is his permanent domicile and files for divorce under irretrievable breakdown.
Which was not a recognized ground under the Hindu Marriage Act at the time. The Nevada judge grants the decree ex parte.
The husband flies back to India and uses this piece of paper to block his wife's claim for maintenance.
The Indian Supreme Court has to decide if they recognize this Nevada paper, and to do that, they turn to Section 13 of the Civil Procedure Code.
Section 13 is the absolute bedrock of foreign judgment recognition in India.
I think of it as a 6-point security checkpoint at an airport. If a judgment fails even one check, it's denied entry.
Let's run the Nevada decree through the checkpoints. Checkpoint 1 must be pronounced by a court of competent jurisdiction.
Why would a Nevada judge have authority over an Indian Hindu marriage?
The Supreme Court agreed. They held the Nevada court lacked foundational competence because 90 days of residence wasn't recognized by the law under which they married.
Fails checkpoint 1 instantly. Checkpoint 2, given on the merits.
The wife didn't submit to Nevada's jurisdiction. It was ex parte, not a true contest.
Checkpoint 3, must not be founded on an incorrect view of international law or a refusal to recognize Indian law.
He used irretrievable breakdown, a ground completely unavailable under the Hindu Marriage Act, a blatant refusal to recognize applicable Indian law.
Checkpoints 4 and 5 deal with natural justice and fraud.
And the Supreme Court came down incredibly hard on fraud. He lied to the Nevada court about intending to make its permanent home just to manufacture jurisdiction.
Fraud unravels everything.
It does. It vitiates the decree entirely.
And checkpoint 6 is breach of Indian law, so the Nevada decree failed spectacularly.
The Supreme Court completely refused to recognize it, granted the wife maintenance, and stated that rules of PIL are made for men and women, not the other way around.
They chose to protect the abused citizen over respecting the foreign decree, which brings us to the human cost of these loopholes: non-resident Indian, or NRI, marriages.
A severe social issue. The Niraja Sarah v. Giant v. Serif case outlines this tragic pattern.
A highly educated NRI groom returns to India, marries a local woman with a massive dowry, takes her on a brief honeymoon, and leaves for the U.S., promising to send for her.
But he disappears. Months later, she gets a legal document. He used a foreign court to unilaterally annul the marriage, claiming they never cohabited.
Leaving her socially stigmatized in India, economically drained, and legally stripped of all rights to maintenance by a judge she's never met.
Is a jurisdictional hit and run. The Supreme Court was so appalled, they basically begged the government for new laws.
They made 3 feasibility recommendations. First, no NRI marriage taking place in India should be capable of being annulled by a foreign court.
Removes the weapon of forum shopping. Second, adequate alimony must be payable from the husband's global property.
Follow the money. And third, making Indian decrees executable in foreign courts via reciprocal agreements.
Desperate pleas for global cooperation to stop domestic abuse via legal loopholes.
Now, there is a very specific requirement in the syllabus about matrimonial reliefs in respect of polygamous marriages.
This stretches the core philosophy of PIL to its breaking point. your personal law travels with you. But what if your personal law permits multiple wives and the local jurisdiction enforces monogamy?
Or vice versa. Lord Brougham's illustration really helps here.
Yes. Imagine an Englishman whose personal law strictly prohibits polygamy.
Yeah.
He travels to Turkey, which at the time permitted it. Can he marry multiple wives?
The local registrar might say yes, but his essential validity is governed by his domicile, England.
So he absolutely cannot enter a valid polygamous marriage. His restrictive personal law travels with him like an invisible cage?
But flip the scenario. A man whose personal law permits polygamy travels to England, where the local laws provide absolutely no form for a polygamous marriage.
If he marries one woman in England, utilizing local monogamous forms, the marriage is valid. However, the nature of that marriage, its potential to be polygamous, is still governed by his personal law.
The gravitational pull of domicile is just immense.
It defines your civil status, even if the local jurisdiction refuses to facilitate it.
Wow. Okay, moving into the aftermath. The marriage is dissolved. Now we face the collateral damage, the children, and the finances.
Right. Foreign custody orders. How does an Indian court handle a UK or US judge demanding a child be taken from a parent in India and returned?
It's a terrifying clash of principles, the comedy of courts versus the best interests of the child.
The syllabus highlights Suryavadanan versus Shilpa Agarwal. In Suryavadanan, the parents were British citizens, kids raised in the UK. The mother takes the kids to India, and the father gets a strict UK return order.
The Indian Supreme Court leaned heavily toward comedy here, right?
They did. They reasoned the UK court was the most appropriate forum to conduct the welfare inquiry. They ordered the children returned.
But wait, if an Indian court blindly respects foreign orders, aren't they potentially forcing children back into abusive environments? A mother fleeing violence doesn't have time to ask a foreign judge for permission to leave.
That is the nightmare scenario, and precisely why the Suryavadanan approach is not an absolute rule. The Shilpa Agarwal case clarified this.
How did Shilpa Agarwal shift the framework?
The Supreme Court established that a foreign custody order is merely one circumstance to be considered. It is a piece of evidence, not conclusive.
The domestic court has to do its own independent inquiry.
Exactly. Does the child have roots in India now? Are they thriving? And most importantly, does returning them pose a risk of harm?
And if returning them is dangerous, the domestic court will override the foreign decree. The child's safety trumps comedy.
The apex principle.
Thank goodness. Now, what about the finances? Enforcement of foreign maintenance orders. You win a maintenance decree in London, and your ex empties his accounts and flees to Mumbai.
How do you force him to pay? This brings us to Section 44A of the Civil Procedure Code.
And it revolves around whether the judgment is from a reciprocating territory or a non-reciprocating territory.
The central government publishes a VIP list of reciprocating countries in the official gazette, like the UK, Singapore.
So if my order's from the UK, a VIP country, how hard is it to get my money?
Very streamlined.
Yeah.
You file an execution application in Mumbai, and the judge treats it exactly as if it were a local Indian decree. Fast track to garnishing wages.
But what if the judgment is from a non-reciprocating territory, like in the marine geotechnics line of cases?
A nightmare begins. Section 44A does not apply. You cannot simply execute it. You have to file a brand new civil suit in India.
I have to sue him all over again based on the foreign judgment?
Yes, and the Indian court will force that foreign judgment through the grueling 6-point security checkpoint of Section 13 all over again.
And there's a ticking clock, right?
A strict 3-year limitation period from the date of the foreign judgment to file the new suit in India. Miss it, and you recover nothing.
That is just exhausting. Without those reciprocal treaties, borders become impenetrable shields for spouses trying to evade responsibility.
They really do.
We have covered an immense expanse today. Looking back across the scope of PIL, what is the ultimate takeaway?
PIL is a desperate, constantly shifting balancing act. We saw courts attempting to create predictable rules, like strict domicile or rigid formalities.
But those rigid rules crushed the people they governed, so the courts had to evolve.
They embraced real and substantial connections and acted as strict border guards against fraudulent decrees. It's about respecting global legal harmony while fiercely protecting individual humans caught in the crossfire.
The law attempting to map the messiness of the human heart across geographical borders.
Wonderfully put.
But before we sign off, I want to leave you with a provocative thought. We spent this whole deep dive talking about domicile as the absolute anchor.
A physical tether to a specific geography.
Right. But think about the modern world. Digital nomads. A couple meets in Bali, they log online, and they get married via a Zoom wedding officially registered in Utah, which permits virtual ceremonies.
A marriage celebrated in the cloud.
Exactly, and then they live out of suitcases. 3 months in Portugal, 3 months in Thailand. They own no real estate, they have no intention of settling down.
Their domicile is essentially in motion.
How long before the very foundational concepts of private international law domicile, lex loci, become completely obsolete? If a couple truly lives everywhere and belongs permanently to nowhere, whose laws protect them when that Utah Zoom marriage inevitably falls apart in a coffee shop in Lisbon?
That is a staggering dilemma. The entire architecture we discussed requires a physical anchor. When humanity becomes untethered from geography, the traditional conflict of laws, rules, will simply collapse.
It's a profound challenge for the next generation of legal scholars. It really reminds you that the law is never finished. It's always racing to catch up with how we choose to live.
Absolutely.
Thank you so much for joining us on this incredibly deep dive into the complexities of cross-border love and law. The world is vastly complicated, but the attempt to bring order to that chaos is endlessly fascinating. Keep questioning the invisible borders around you, and until next time, keep diving deep.